Welcome. My name is Mark Blatstein, the physician founder of Physician Presentence Report Service. Today, I'm going to discuss preparing for the do's and don'ts of life inside. Once you've been criminally indicted, sentencing preparation starts. Don't wait. And this is not me saying it, it comes from multiple federal judges. It's really never too early to begin to prepare. This is your life. And so when you have an attorney, and if the attorney's telling you it's too early to prepare for, if it's a criminal and it's trial or it's a plea and your attorney's telling you it's too early, you don't blame it on me, but you can blame it on federal judges, and I'll give you all the documentation that you need. But you need to prepare you for your interview because it's your life on the line. You may be paying the attorneys, but it's your life. They're going to draft what's called your pre-sentence report, and your pre-sentence report is going to dictate your future. It's going to dictate everything that happens to you, and it's going to be after you're in prison. Once you're in the BOP or Federal Bureau of Prisons, you're going to be on your own. Your lawyers for most things are not going to be able to help you. And so some of the do's and don'ts of life inside prison, we're going to go over with you right now. But part of when you initially are interviewing lawyers, if you've paid your attorney and you've paid, let's say, to go to trial and you wind up pleading, and let's say you want to engage someone, I'm more than willing to work with you. I'd love to, but someone like myself to help you prepare for your pre-sentence interview, for your to draft a narrative, which is your life story, your life history, to prepare you to speak with your judge, called your allocution, a release plan, what to expect in prison. Like you, I mean, I had a felony conviction in 2009, 2010. I got my medical license back. I've been working with individuals like you for years. You want to get there okay, that they can release some of the funds back to you because you've paid them and you can get some of that money back too. If it's not for me, it's for someone else. But this is your future, it's your life. So, some of the do's and don'ts of life inside. Some of the important issues I'm going to cover with you. First step back, as soon as you get into prison, there's going to be, if once you have time to get to a computer, it's going to be your risk assessment survey. And when you take these first step act programs, you're going to get earned time credits. If you stay out of trouble, you'll get good time credit. But if you don't take the survey and your case manager, unit team, we can go through them at another point in time. They give you programs to take. They'll give you the programs, but if you haven't taken that assessment survey, you're not going to get those credits. Restitution. If you have a financial crime and you will, when you go meet with your case manager, they're going to want you to participate in what's called a financial responsibility program, FRP. If you refuse to do that, you may not benefit from earned time credits. You may only be able to get a limited amount of earned time credits, limited amount of commissary time. There may be you may get limited early release or no early release. And so you really want to participate with those financial restitution or the financial responsibility program. If you have there's like what's called a commissary trust account, which is where when you have money deposited to your account, if you have a restitution order or you owe fines or money, don't put a lot of money in there, like thousands of dollars, because you may wind up going into that your account one day. The Department of Justice would love to go through that and take out 75%. So you don't want to keep a lot of money in your account, but if you don't owe any money to anyone, then you can keep as much money in there as you want, and money can be sent in there via. There's a lockbox rather, with the Federal Bureau of Prisons. There's MoneyGram, there's Western Union, etc. Medical. I'm a physician, so I have a keen interest here, but this has to be if you have a medical file, medical record, it's a lot of work between you, your attorney, and your physician. And if you have more than one, then all your physicians. Medications, the Bureau, just like you have medications on your out here in the free world, in the Bureau of Prisons, they have what's called, they're on formulary, which means that they're medications that are available, generic. They have medications that are non-formulary, which means that they're generic still, but you're not going to get them. And so you have to go through with your physicians and go through all the drugs that are available, and I'll go through them with you a little bit later. And if the drugs are available, you want to make sure that your drug is on that list. But your physician also needs to note this in their records so that you have a copy of all your medical records and why these drugs are very important to you, not a substitute. You want to make sure if it's not on formulary, that it's a non-formulary drug, why the drugs that are on formulary list, why they are not appropriate for you, and the non-formulary drugs are. And they have to go through drug by drug and make sure that the drugs that are available, why they will not work. This is the non-formulary list, part one. Generic drugs, I would assume most of you understand this, but in case you do not, for each brand name drug by a manufacturer, there may be a half a dozen generic manufacturers. And each of these drugs are similar, but they're different in size, shape, and color. Now, it is true, although they say that the drugs are exactly the same, they're not exactly the same, but they're the same enough to get FDA approval. Let's say the drugs are not available. Is there a plan? Well, this requires more work between, a consultant like myself, your doctor, and your attorney. Ultimately, it's to make sure that everyone's on the same page, that your records are detailed, so that during the sentencing hearing, well, initially with the probation officer at the pre-sentence interview, so that everyone's on the same page, and then at the sentencing hearing, that the judge is able to note verbally on the record that he understands that the Bureau of Prisons doesn't have that medication, that he also understands that they do not take the orders from the court regarding treatment, orders for treatment, or for medications. But with that said, if in fact your health begins to wane or is adversely affected because you're not getting that medication, then there is an avenue for compassionate release back to that same judge. Again, if you have medical devices, CPAP, BiPAP, prosthetic devices, diabetic soft shoes, etc., all the medical records, you need to have everything if you have a big file. And you can bring that file in with you in an envelope if you self-surrender, called legal mail. You can also have that entire file organized and presented to the probation officer at the pre-sentence interview. If you have diagnostic tests, MRI, CT scans, lab scans, whatever the diagnostic tests are, they can be on CD or a thumb drive. I think a CDs probably makes better sense, so that can go into the Federal Bureau of Prisons, as attached to your, in addition to the printed report. Most doctors, at least that are worth their salt, would rather see the actual test. Copies of surgeries, labs, everything needs to be there, including your physician's contact information. Even with that, everything can be correct. And I'll go through, the actual press release, but, a gentleman went in, cheap drug, diuretic, hydrochlorothiazide, 50 milligram. The Bureau of Prisons went ahead on their wisdom, reduced it. The guy, his blood pressure went out of whack. Then they went ahead and went from a diuretic to a vasoconstrictor, lisinopril, and he wound up in the emergency room. They didn't follow the treatment that he's presented with the medication, with the physician records, and the judge had to provide compassionate release. But he had transient ischemic attacks, he had strokes, he was a mess. Another example where a federal judge held this particular federal prison in contempt because the patient or the inmate wasted away due to untreated cancer, and eventually, he held this particular BOP facility in contempt because they just didn't even listen to the court. They wound up the BOP facility finally didn't provide him. They forced the family to pay. There was Dallas Fort Worth. They drove the defendant to the airport, left him in a parking lot on a bench there, didn't leave him with the wheelchair, and it was only Good Samaritans that helped him into the airport. And then he was soiling himself the whole time until he got to his home in Florida. What can you do? I'm not going to spend a whole lot of time with personal narrative, practicing to speak with your judge, called the elocution, getting letters that attest to your character, a release plan. But the administrative remedy process for the medical problems or for any and all grievances is what the Federal Bureau of Prisons wants you to do. And if it's a medical problem, you don't have to jump through all of the hoops at the same time. You don't have to go through all of them, which I'll go through later. If you're coming in and you're a bit older, you maybe have had, a large major joint replacement surgery, unstable gait, you have problems with your back, shoulder pain, foot pain, you have tinnitus, other medical issues, you may need a lower bunk. If you've come in with Raynaud's, you have diabetes, poor circulation, bone deformities of your feet, but you're predisposed to ulcers, a soft shoe may be indicated, but again, documentation in your medical file that you're providing. We've all read about, the Federal Bureau of Prisons has had, too many, changing directors. They have a problem with staffing, finances, culture. there's a crumbling infrastructure. So we can only be responsible for the things we can control. And if you go in with a plan, and it's important that if you go in with a kind of a routine that you're going to follow, and a kind of a plan to follow, and it won't be easy, but if you do that, it will help you get through the process somewhat simpler and get out the other end possibly earlier. Other things that will be reviewed is how to do visits, money, mail, cell phone, stay away from, email commissary, BOP placement recommendations. If you're eligible for the drug program, public safety factors, you don't want to be a kingpin, etc. And again, this is not me making all of this up. I'm not that smart. It's that all the advice I'm sharing with you comes from other federal judges: Robert Scalia, Patrick Schultz, and Mark Bennett. So let me share this screen and let's see if I can do this. And hopefully I can share that. Will it work? It did. Okay. And so here we have the Bureau of Prisons. This is their drug program. No, that's not. This is the generic on formulary medications. These are available. These are both on formulary generic and over the counter. There's 3,500 drugs in this list. It goes on and on and on. I'm not going to go through each and every drug. There's a gajillion. Next, just because it says it's on formulary, it still needs to be written by your physician very clearly that you've been on it and why this is important for you to take and not be changed. This is the non-formulary. Here, I'm going to start here and say that the court orders recommending or orders specific treatments should be referred to the appropriate Federal Bureau of Prison attorneys. They cannot, the Bureau of Prisons is not going to take an order from the court. Going backwards here, that these are the non-formulary drugs. And again, there's a lot. This is a whole packet here. This is the gentleman, Judd Blast, this individual, Nick Bovis. He came in with 50 milligrams hydrochlorothiazide. They went ahead and reduced it to 25 milligrams. He had problems. They changed it to lisinopril. He wound up in the emergency room, and the judge got mad because he had to do a compassionate release. And the judge made me mad, but Judd said he did that just because he was sentenced to prison. Didn't mean it to be a death sentence. This is the other individual. Judge holds Federal Bureau of Prisons in contempt for letting this gentleman waste away in prison. And the last one I wanted to show you here to pop off the screen here, I believe, is this. The administrative remedy process. Essentially, there we go. It has 4 parts. Essentially, your complaint has to be the same in each of these 4 parts. When you do the informal, which is the BP8, you just talk to your case manager. And after you talk to them, what you have to do is you have to keep your own calendar. They have, they have 24 hours to respond. It says here you have 20 days from the date of the incident, but they have 24 hours here to respond. Next is a BP9 to the warden. There they have 20 days. And that 20 days, this goes to the warden. So you're going to go ahead and you're going to use the same complaint here as you're going to put here and what you're looking for. And then you're going to copy this on a copy machine, or you're going to 2 or 3 times, or you're going to write it out by hand 3 times. And you're going to do the same process. You don't hear anything or you get a negative response, you're going to do the same thing here. If you haven't gotten within 20 days, then you're going to do the BP9. And this is BP9. You're going to wait 20 days. Let's see here. This is BP10. You're going to wait with the BP10. Let's see, if you didn't get a response within 20 days, you're going to send this to the BP10 within 20, and you're going to wait 40 days. After BP10 within 20 days, yeah, you're going to wait 20 days for the BP10. And after that, you're going to wait for the BP11, and then that's going to go ahead and that's going to go in 30 days. Now, this could go to 40 days if they say that it's okay. If they're, that they may extend this for you. And now you're going to go ahead and you're going to wait some more time. But this here, the director's response deadline is 60 days after you filed the BP10. This one, the BP10, is 40 days after you file the BP9. And when that doesn't happen, then from here you go to to a 2241. This is all to the calendar. They don't have to reply to you, but if you hear nothing, you have to take the next step proactively. And on that note, I hope that you have found this helpful. I realize there's a lot here. And ultimately, if you're going into if you've had that indictment, and at this point, a lot of them are not criminal anymore, they're civil, pay the crime, pay the fine, or pay the amount of the whatever the judgment may be. But if it turns to be criminal, the Department of Justice has a 98% conviction rate, but it's between you and your attorney as to what you do. At that point, you need to be prepared to really advocate for yourself, which is having that heart-to-heart feeling inside and develop your own story, your narrative, what brought you to this point, because judges understand the crime doesn't happen in a vacuum. They come into your sentencing hearing with a sentence for you already in mind, and you can change their mind. But that starts with changing the mind of the probation officer at the time you have your pre-sentence interview. I hope you found this helpful and have a good day.